Good morning. I'd like to call this hearing to order. Thank you all for being with us. In light of the April 15th occurring on a weekend and yesterday's D.C. holiday, today, Tuesday, April 17th, is tax day. We are glad to have the IRS with us to discuss a matter that is critically important for small businesses and all Americans saving for retirement. Small businesses have a number of options available to offer their employees when it comes to retirement plans. Most fall under one of three categories: defined contribution plans, defined benefit plans, or the various employer-based individual retirement accounts, also known as IRAs. To encourage and incentivize savings, many of these options also include tax advantages. Unfortunately, research shows that not all small businesses are utilizing these options, and small business owners often cite resource and cost issues as the reasons they do not offer retirement plans. This cost issue is why the recent user fee change implemented by the Internal Revenue Service to its volunteer correction program is concerning. Small businesses often do not employ an army of compliance officers to interact with the IRS. Instead, it is frequently the owner who sacrifices time away from growing and expanding the business in order to attend to tax matters. Because of the complexity of the filing process, businesses can utilize the volunteer correction program to correct and fix plan submission errors before an IRS audit commences. In order to utilize this program, a user fee is charged. In January of this year, the user fee schedule was altered by the IRS. It went from a table of 6 different fees corresponding to the number of participants in the plan to 3 different fees based on a retirement plan's asset size. The lowest fee went from $500 to $1,500. That is a significant increase for any business, especially a small business that operates on the margins. From main streets in my hometown of Virginia to communities across the nation, small businesses play an important role in the local and national economy. Retirement plans are a key ingredient for hiring, employee retention, and business expansion. Thus, retirement plan offerings are important to achieve small business success. It is for these reasons that small business equity is critical when it comes to compliance issues. I am looking forward to our witness addressing many of these important topics and helping our subcommittee better understand the recent user fee change. This subcommittee strives to create an environment where small businesses, entrepreneurs, and startups have the opportunity to grow and expand. Today's testimony will help us as we continue to monitor the small business ecosystem. I now yield to the ranking member for his opening remarks.
Thank you, Mr. Chairman, for holding this hearing. As part of their retirement planning, most Americans rely on their employer-based retirement plans. As our population ages, it is critical that small employers and their employees have access to quality financial security in their retirement years. But only 14% of small firms offer such a benefit. Small firms not only face the challenge of offering a retirement vehicle, but enrolling their employees. Roughly 50% of the private sector workforce participates in an employer-sponsored pension plan. We can do better and have made strides in increasing that number. However, recently released revenue procedures from the Department of Treasury may have caused us to take 2 steps back in our effort to increase retirement savings. While it is important to recognize and applaud your efforts to provide relief and fairness, the action taken by the IRS may disproportionately harm small firms. It could even cause small businesses to eliminate their plans. The Internal Revenue is one of the key pieces to maintaining a healthy national retirement system. They have the important job of ensuring compliance, fairness within plans. And because they cannot ensure that every plan is complied with the relevant rules and regulations, the Employer Plan Compliance Resolution System was created. This system is an important tool allowing plan sponsors to correct mistakes and avoid disqualification of the plan. It gives them a predictable and streamlined process for fixing independent mistakes at a fair fee. Doing so has encouraged the sponsorship of many retirement plans and the fiscal security of workers. I call this a tool in our retirement toolbox. Yet the IRS abruptly and without notice made substantial changes to the voluntary correction program within this system. Rather than base fees on the particular plan size, the IRS now charges fees based on the plan asset value. And they have not provided any evidence suggesting this change was merited and the amounts reasonable. This leaves me very concerned about the future state of our retirement system and the costly consequences it will make to have to our small plans. But most importantly, I hope this hearing will provide more information not only on the facts and circumstances behind this decision, but why the IRS did not allow the statutory mandated requirement to consider the special concerns and circumstances that small employers face with respect to compliance and correction of compliance fairness. I understand that fees must be adjusted and changes over the years, but such drastic actions by the agency leaves me speechless over the disregard of how this affects small employers and workers all around the country. These consequences do not conform to the committee's effort of assisting small firms with their retirement goals. Any policy regarding retirement plans should ensure small employers have the resources they need to overcome challenges in compliance. It's not only in their best interest, but our entire economy. For this reason, we need to make sure that the retirement plans are attractive for small businesses, as their retirement savings is an integral part of our nation's future. And this is why we are here today. This hearing will give us the chance to gather information about the rule, how it will harm small businesses, and why the IRS needs to rethink and reverse this rule. Remember, first, do no harm. I thank the witness for being here today, and I yield back the balance of my time, Mr. Chairman.
Thank you, Mr. Evans. If committee members have an opening statement prepared, I'd ask it be submitted now for the record. I'd like to take a moment to explain the timing lights for you. Although today we just have one speaker, I think we'll be in good shape. You have 5 minutes to deliver your testimony. Light starts out green, then yellow, then red. All right, I shortened that up. Our only witness today is Ms. Sunita Lowe. Ms. Lowe is the Commissioner of the Tax-Exempt Government Entities Division at the IRS. However, she is currently on assignment leading the IRS in its implementation of the recent tax reform legislation. With over 2 decades of IRS service, Ms. Lowe has served in roles with the IRS's Large Business and International Division, the Office of Chief Counsel, the Office of Tax-Exempt Bonds, and the Office of Federal, State, and Local Governments. In addition to her public service, she has nearly a decade of private practice experience. Ms. Lowe has a Juris Doctorate from George Mason University and a Master of Laws from Georgetown University. We know today is a big day for the IRS, so we appreciate your participation. We also appreciate the expertise that you will share with us today. You're recognized for 5 minutes, and you saw that, as usual, the Democrats and Republicans are in total unity on everything up here. And today, you did see us agree on something, right? So if you want to zoom in after your 5 minutes and spend a couple minutes on probably the primary issue we're here, and then we can go to questions after that, and you may begin. Thank you very much.
Chairman Bratt, Ranking Member Evans, and members of the subcommittee, thank you for the opportunity to testify on small businesses and the IRS Employee Plan Compliance Resolution System, or EPCRS. Since January, I've been in a temporary posting as the director of the IRS Tax Reform Implementation Office, having stepped away from my position as the Commissioner of Tax-Exempt and Government Entities Division. I was serving in TEG at the time of the fee change at issue. At the IRS, an important goal is to help small businesses. They are a critical part of the nation's economy, helping provide jobs for millions of taxpayers. Small businesses face unique challenges complying with the complexity of our nation's tax laws, and the IRS wants to do everything it can to assist them. The topic of today's hearing is an important one. The law involving qualified retirement plans is complex, and it is easy for a small business or their plan administrator to have issues navigating the rules. These retirement plans are critical to small businesses as well as the employees who participate in them. At the IRS, we want to do everything we can to help small businesses stay on track with their retirement plans. To help them navigate plan issues, the IRS has worked hard to offer ways businesses can correct mistakes as simply as possible without jeopardizing their plan status. This is important for everyone involved: the small businesses, their employees, and the tax system. This is a complex area, so I'd like to take a moment to walk you through some of our retirement plan correction programs designed to help on these issues. EPCRS is a comprehensive system of correction programs designed for retirement plans, including small employers, to help correct technical mistakes. Qualified retirement plans offer significant tax benefits to employers and employees, including current deductibility of certain employer contributions and deferral of tax on the retirement fund. Yet these benefits are available only on fulfillment of numerous legal requirements that govern eligibility, vesting, and distribution, which can confuse employers, especially small businesses, who sponsor qualified plans. EPCRS offers relief from errors in form or operation that would otherwise result in significant tax consequences to the employer, the employee participants, and the trust fund. Within EPCRS, the Voluntary Correction Program, or VCP, allows plan sponsors proactively to identify and correct a wide range of operational or form failures. To enter VCP, the plan sponsor completes an application form that identifies the mistake, proposes the appropriate correction method, and remits a fee for the IRS to review the application. Upon approval, the IRS issues a compliance statement indicating that the correction was proper. This is important because it allows the plan to avoid the serious tax consequences that a plan sponsor and participant would face if a plan lost its qualified status due to a failure. Under VCP, the IRS can review the correction and work with the plan sponsor, adjusting the correction method to resolve complex mistakes. In 2018, the VCP were set on 3 tiers based on the amount of plan assets. The changes were necessary to more accurately reflect resources required to administer the program. These fees were determined by multiplying the average hours to complete a case for each category by the hourly staff cost. I would point out that the new structure called for charging the smallest plans $3,000 per application, but we reduced that to $1,500 out of special concern for small employers. I would also like to mention another important component of EPCRS, which is the Self-Correction Program, or SCP. Under this program, a plan sponsor can correct plan failures without filing an application with the IRS or paying any fees, as long as the failure is corrected in a timely manner, and that is 2 years. This can be a very helpful and less costly option for small businesses when they discover mistakes in their plans. The IRS is continuing to work with small businesses, business community to find ways within the scope of the law to expand and improve SCP. For example, we will be meeting with several key small business organizations, including the Small Business Council of America, in early May to discuss such improvements. Chairman Bratt, Ranking Member Evans, and members of the subcommittee, the IRS is committing to doing everything possible to help small businesses that sponsor retirement plans and ease burdens they may face in administering their plans. This concludes my statements. I would be happy to answer your questions.
Thank you very much for your testimony, Ms. Lowe. I'll start out with a couple general ones, and we'll move on through the committee. First, with your current responsibility leading the Tax Reform Law Office at the IRS, I wanted to begin with just a general question. And I realize the scope is pretty big, but how is the implementation of the tax reform law moving along in your view? And just kind of a summary statement.
So as you know, that this is the largest tax reform in the last 30 years, and we have a number of provisions, and much of it is as a new tax regime, as you know, in the international area. And we have a team working on it, and we have made quite a bit of we've moved forward quite a bit. Forms, we expect to get all the forms done, the new forms done, and the revisions by the end of this month, and early release maybe by midsummer, the instructions at the same time. And we are hoping to issue guidance we've issued a lot of frequently asked questions and facts and some guidance fairly fast. And we expect to issue most of it in some proposed forms so taxpayers know what to do before they file their season. I'm confident we're going to have a good filing season next year.
Good. Well, that's
Yeah.
great. Thank you very much for that. And then changing topics a bit, I know that our chairman was just in the room. Chairman Shabbat sent a letter in December to the IRS on their enforcement of Obamacare's employer mandate and its impact on small businesses. And can you let our committee know when the IRS will respond to our chairman's letter?
Oh, I'm not aware of it, but knowing, we are very responsive, and I'm sure he will be getting a response.
Great, and thank you very much
Yeah.
for that. And then you just mentioned, I don't think any of us have the entire complexity in mind. And you just mentioned another alternative avenue for small business to pursue that doesn't have the fee attached. Is there a downside to pursuing that avenue?
There is no downside to produce. It's a great thing. They don't have to come in, they correct, and they just keep it within their records, and there is no fee. The only time they can't come in is if there are tax consequences. Not the only time, but one of the times that, for example, they can't come in if third parties taxes. There's a tax consequence. For example, if it would affect the participants' tax consequence then they have to come in to us because they have to provide us that information that they may not have. And so as I stated, we are meeting with the small business, a number of interested parties, including the Small Business Council of America. I think it's first week of May, to discuss further what types of programs can we include in the self-correction. It's good for them. It's good for us. It doesn't take our resources to work on those self-correction programs.
Yep.
And it's also good for them because they can do it themselves and not have to pay any fee.
Okay, great, thank you. And when you change the metric, it's almost hard to kind of think through the change in the metric, but it went from kind of a employee-based to an asset-based metric in assessing the fee that goes to each size. And can you just give us the quick logic on why the move in the change from number of employees to assets?
So number of participants doesn't necessarily show the size of the plan. You can have a one-person plan with a large a large asset size, or you can have a number of participants. So to us, the fair way of looking at it is the size of the plan. But we also sliced and diced the data every which way to find out, does it matter how many hours we spend on a case, whether it's number of participants or the asset, or whether it's a small employer or large employer? What we found was the hours we spend were comparable. Whichever way we look at it, if it's a large plan, we spend approximately the same amount of time we do for a small plan, or whether there are 12 participants or there are 1,000 participants. It's the complexity of the issue, not the size of the assets. And we are required government-wide to use the OMB Circular 825 to determine user fees. So we look at the time spent and the cost of the time, and what we came out was $3,000 for small businesses. And we understand that's a lot of money. So we cut it down to $1,500, but it's also only a one-time fee. It's not a recurring fee. Once they correct their plan, we hope that the plan administrator is watching over the plan for them, because they sell the plan documents to them and they look at the plan documents. They keep up with the amendments. So the small employer can keep doing what it's supposed to be doing, running its business, and not have to worry about the retirement plans.
Great, thank you very much. I think with that, I'll yield for a few minutes and go through the committee, and I may come back. And so with that, Mr. Evans.
Thank you, Mr. Chairman. The goal of this committee is to assist small firms in providing retirement plans, because only about 14% of employees do so. Can you explain whether the IRS studied how higher fees could affect compliance rates and sponsorship of retirement plans, particularly as it relates to small? The thinking is what I'm most interested in.
No, we did not study how it would affect, because it's hard for us to figure out how that would affect. But we did look at how much time we spend on the entire population that comes in. And I also want to make a point that it is out of the, I have the data, out of the 694,000 plans, only 3,390 came in 2015. That's 0.5% of the plans, entire population of plans that have to come in. So it's a very small percent of plans that have issues that come in at least. A lot of them self-correct. And it's only a one-time fee that they have to pay. And the other thing is it really didn't affect the time we spend on it, whether it is participant-based, whether it's a small plan or a large plan. So it's hard to tell how it affects the plan community. The one thing also to keep in mind is if they don't come in voluntarily and we pick this plan for audit, the effect on the plan can be catastrophic if the plan is picked for audit and then doesn't enter into a closing agreement. That amount of closing agreement sanctions in an audit is far higher than the $1,500 or $3,000. And if there is no resolution, there's tax consequences to the participants who did nothing wrong, or the employer who actually retained experts to look at its plan, and the employer's running his business. So we want to protect the innocent participants here and offer this program, and also expand as much as we can the self-correction program. So to the short answer, we don't know how it affects, but we think it affects them positively because they can come in without having to worry about an audit and the huge tax consequences on them.
You was just, maybe this is just a piggyback on, can you further explain how IRS made the determination to base the user fee on the value of the plan? What's your sense of how they made that determination?
Well, we looked at whether the hours spent by number of participants
Right.
is less versus assets. We looked, and we spend the same number of hours whether we charge the fee by number of participants or the number of assets. But the 6-tier fee that we used to have before this one was confusing to the plan participants because it was also based on the type of failure sometimes, and it's also the participants. So the 3-tier fee intent was to simplify the fee structure. You can look and say, oh, I fall within this category, this is what I have to pay. Plus, we use the government-wide user fee requirements that OMB has put out to make a determination. We looked at the hours we spent on an average on different types of plans, whether it is by asset or by participants, and we found it didn't matter. Whichever way we sliced the data, it didn't matter. And so we cut it, so we came to 3,000 for the small plans, 500,000 or less, and we thought that was a little high for them, so we cut it down to 1,500. And I just wanted to add was that we have a meeting with the community to look at see how we can offer more self-correction programs so they can do it themselves and not have to come in. The other thing is, since the last year and a half, we've changed how we work the cases that come in, and they've become much more streamlined. So it's a biennial review. So when we review again, I'm guessing, because we have streamlined the process, the hours will go down for everybody, not just the small businesses, but even the large. And so by OMB requirements, we will have to look at the fee again. And if the hours go down, that means the fees will go down.
I thank you, and I yield back the balance of my time, Mr. Chairman.
Thank you, Mr. Evans. At this time, I'd like to yield whatever time the Congressman from New York, Ms. Clark, needs.
Oh, thank you, Mr. Chairman, and I thank the ranking member, Mr. Evans. I thank you, Ms. Lowe, for coming in this morning to testify. Every American shares the dream of being able to afford retirement. However, a 2017 study by the Pew Charitable Trust found that 40% of workers do not have access to employer-provided retirement options. Small businesses are particularly hard hit as they often have fewer benefits to offer employees. They were also particularly affected by Revenue Procedure 2018-04, which restructured the voluntary compliance program to be based on asset size rather than on the number of participants. Ms. Lowe, Section 1101 of the Pension Protection Act specifically directed the IRS to take into account the special circumstances that small businesses face with respect to retirement plan compliance. Yet some have claimed that the new fee schedule raised compliance costs on small employers by up to 600%. Is this the case?
So the prior fee structure was based on the number of participants. And number of participants it wasn't based on asset size. So the number of participants doesn't necessarily mean that the plan asset is less. So to do a comparison of what it used to be, which wasn't even based on the user fee required by OMB, to what it is now is actually comparing apples to oranges.
I understand that before an employer with such again, the apples to oranges change, the bottom line doesn't necessarily recognize that. It's recognizing what the cost is to the company.
The cost to the company, some small employers, if they based on the participants, if they were small, were paying 500, and now those same employers, if they fall in the same category, you're right, they will be paying 1,500.
Right. So I just be a bit concerned. And do you think that really comports with the goals of Section 1101?
So we are required, for all the rest of the IRS programs, we use the user fee set forth in OMB Circular 825. The prior program based the fees on the sanctions that the resolution, what type of resolution, what type of error was occurring. And what we did was we changed the user fee, the way we compute the fee based how we do it government-wide and IRS-wide based on the number of hours spent on each case and the hourly cost as directed by OMB Circular. So so now we have the same way of doing fees used for voluntary compliance in the rest of the IRS and for other programs.
I understand that, but I mean, I think small businesses are unique. And I don't know that sort of a blanket regulation takes into account the nuances and uniqueness of small business. Was that part of the discussion at all when you got to the point of where you felt that there needed to be, I guess, a blanket user fee calculation for all that fall under Section 1101?
So we did take that into account, and we reduced the fee that would have been by 50%.
Okay. Well, my understanding is that the new user fee structure was announced with little advance notice to plan sponsors. Many submissions were ready to go and awaiting a plan official to sign the paperwork after the holidays. Did the IRS consider whether taxpayers should be permitted a transition period to submit VCP applications under the old fee schedule?
We did not consider that, but that in the other areas we have noticed is when we have a transition period, it is far more confusing to the taxpayers because they have to look to see where it applies, and it causes a lot more confusion versus the application.
So you're determining whether the confusion is comparable to the hardship?
Well, this is a one-time fee.
I understand that, but
yeah.
if you're not planning for an increase in fees, it becomes a hardship when the change is so drastic and there's no planning for it on the part of the business owner, especially for small businesses.
Well, I don't recall exactly when the REPRA came out, and there was a time between when the REPRA comes out and when the fees are applicable. But we can look it up and see how much.
I would encourage you to do that.
Okay.
ISPARS includes a self-correction program that does not require an IRS submission or user fee. Many stakeholders have advocated expanding it to include loan failures, RMD failures, and other failures. Is the IRS considering expanding the SCP to include these failures?
Well, we have a meeting in early May with the business community, which includes the small business community with the stakeholders, and we are open to looking where we can expand the self-correction program, which is, like I initially stated, it's really good for us and it's good for the taxpayers. But there are certain instances that small self-correction doesn't work, and we need to be very careful where there are consequences to the participants, whether tax consequences to a third party rather than just the plan, and that we need to make sure that it fits into under the self-correction program.
Ms. Lowe, I would want to just suggest that, there be some level of concentration specifically on small businesses. I represent a district where we're really talking about mom and pop operations, and we know that their margin of profitability is very, very slim. So I hope that you will give some consideration to perhaps doing some sort of focus group with a cohort of small businesses so that you can get a far more specific impact, so that they're not sort of put into a pool of businesses that don't necessarily have the same challenges, if you will, that many of our small businesses do in our commercial corridors across this nation. And I thank you for your time. Mr. Chairman, I yield back.
Thank you, Yvette. I'll start up maybe another round of just short questions, and then, Dwight, if you have more, we can go around the loop one more time. I don't know the answer to this question, so I'm just asking it open. What is the average net income of a small business in the country right now?
I don't know the
I know
answer.
average family income in Virginia is about $70,000, and so that when we're talking about these fees, the $1,500 fee, et cetera, I think part of the concerns you're hearing from the entire panel here is in light of that ratio of that $1,500 to, say, $60,000, or even a smaller, right? The smallest of the small, and a lot of the small businesses are losing in the first year or two. And so then you're looking at that, and then I can tell you're obviously professional, skilled, very smart, because when you're making reference off the top of your head to OMB Circular 325s, right? And the problem that we're facing is that's just one out of OMB Circular 325. Well, you're up to 325 regs at a minimum. And then you have all the other government agencies, and I think about $2 trillion in regulatory overhang, right, on the U.S. economy out of $20 trillion. And as an economist, that's hitting my ears the wrong way. And it's not due to you. I think it's due to, at this May meeting, I think we need to assess our pro-growth stance in terms of policy for the country and who should be bearing that $1,500 cost, right? So if you're incentivizing small business and there is no alternative to growth and startups than small business, and without which you don't have public education and all the other social goods you want to have, maybe we should start thinking about who bears the cost in general. Maybe we shouldn't be flipping all of these regulatory costs on the firm, right? Maybe we should apply it in general to society to show society the total cost of regulation in general, and then discuss, is this prohibitive, right? Is this slowing the economy down too much? And so I'm just, if you can comment on this May meeting, you're going to go look for feedback. Will there be economists there who assess, hey, look, this regulatory overhang in general, this is just one small piece, but a small business cannot face up to that number, 1,500 plus a few other of those numbers, and probably survive, much less thrive. And so just your general comments as to how we look at these numbers.
So, this is tax day, and, the IRS we are very cognizant of the need for the small businesses to be able to run their business.
Yep.
That's what they want to do. The plumber down the street or the hardware store, that's what they're in the business of. And they need experts and people like from the IRS to help them with their plan community. They want to provide retirement plans. And so they purchase these retirement plans because they don't draft them. Most of the time they purchase them from plan administrators. And the expectation is that these experts will look after their plans, and because they just want to run their, even given that, and if because the law is so complex, errors get made. The amendments don't get done in a timely manner. There are more contributions that should have been done. Put in. So those kind of things occur because, as we all know, this is a very complex area of the law. So we have provided mechanisms for plans to come in when they find these errors. We want them to find them themselves rather than us finding them on audit. So when we have provided mechanisms for them to come in, and we are looking to provide more ways of them to correct themselves. And we want to encourage people to be more diligent in when they provide their retirement plan, to be diligent, because if they're not, the tax consequences are not good. So we are looking to see how we can reduce the fee by even working ourselves into a more streamlined way, so we don't spend as much time on working these applications. So we're doing two things. We're going to see if we can increase the self-correction program in instances, but it can't be all self-correction, because there are certain things that can't go into the self-correction program because of real tax consequences to the participants. But we're also looking to see how we can streamline the voluntary compliance program so we don't spend as much time. But if we apply user fees, we have to apply them the same way, but we did reduce them. And we have the less time we spend, the less we can charge, or we would charge. So we are looking at how we can help the small business community, but I think we understand that the employers really just want to run their business and not have to worry about their plans.
Right, good. And I hate to ask this question, so be gentle and kind with your response. But with our tax reform, we always try to simplify on behalf of small business and individuals and whatever. Did we, or did we make it, is there even more complexity just because the world adds regulatory and these complex issues grow more complex by the day? I mean, on average, did we make things any simpler for small business? I think we did for individuals, but on the small business side, I'm interested to hear your expertise.
Well, we enforce the laws and we implement the laws as Congress passes them, and we are still studying. Some of the regimes are new, and we are looking at it, the qualified business income credit, for example, or the international regime, and sometimes small businesses can get involved with the international part also. But so to answer your question, we are, some things are new, and we're trying to understand how they will work in the small business community.
Very diplomatic. Thank you. Mr. Evans.
Thank you, Mr. Chairman. After listening to this discussion, you really have sort of made a case of a bill. I just dropped H.R. 5512 to require the administrators of the Small Business Administration to establish a grant program to address rising costs of tax compliance. It seems, and your last statement really says it. I mean, we passed the law, and you have the responsibility of trying to implement it, and here, either intentionally or unintentionally, there's unintentional consequences. I'm hearing that a question was raised, and there's no question. I totally agree with the chairman about economic growth is ultimately the issue that we all are working towards, and that's where we should be. So, as part of why I dropped that bill, aspect of the Small Business Administration, come up with some kind of program on the rising costs, because there's no question that small businesses just cannot afford any more quote unquote burdens put upon them, and we have to find ways to allow them to grow and whatever. That's part of the reason why I asked you a question about the study, and you said you chose not to do the study, but I'm just curious if you dig a little deeper in that, you think that need to be reconsidered, or is it too late to go back and look at the aspect of a study?
We can certainly look to see what effect, if it is possible for us to see what effect this compliance program has on the small business employers to provide the retirements to their plan, but the retirement plans to their employees. We can certainly go back and look at that, see if there is data, and we can make correlations, because they only come in once, and it's a one-time fee. In other words, it's not a recurring fee, so it's hard to. It may be hard, but I'm not a researcher or an economist. But we can ask our research folk to look at it.
No problem. Thank you, Mr. Chairman. You're welcome.
And Ms. Clark, any further questions? Oh, sorry, obviously there's no further questions. With that, did you have any further comments you wanted to offer the committee?
No, thank you for the opportunity to be here.
Thank you very much for joining us here today. Americans face many challenges with regard to saving for retirement. small businesses can play an outsized role in helping formulate a plan for all workers. I think this discussion today will help us as we continue to look at tax issues and all issues facing small businesses, entrepreneurs, and startups. I ask unanimous consent that members have 5 legislative days to submit statements and supporting materials for the record. Without objection, so ordered. This hearing is now adjourned. Have a great tax day.